SADC, it is my distinct honor to welcome you all to this important event where I will present the SADC Electoral Observation Mission, SIOM's preliminary statement on the conduct of the 2023 harmonized elections in the Republic of Zimbabwe. The elections were observed in line with the revised SADC principles and guidelines governing democratic elections 2021 and the relevant laws of the Republic of Zimbabwe. I was appointed as the head of the SADC Electoral Observation Mission to the Republic of Zimbabwe by His Excellency Hakainde Hichilema, President of the Republic of Zambia, in his capacity as the chairperson of SADC Organ on Politics, Defense and Security Cooperation. I maintained close collaboration with members of the Organ Troika, currently comprised of the Republics of Zambia and Namibia and the United Republic of Tanzania, regarding the harmonized elections in Zimbabwe. The SIOM also benefited from the pre-election goodwill assessment mission and report of and advice from the SADC Electoral Advisory Council, known as SIEC. The SADC Electoral Observation Mission comprised of 68 observers. 50 were deployed to the 10 provinces of Zimbabwe, and the rest were based at the SIOM headquarters here at the Rainbow Tower Hotel. Our observers were deployed to Harare, Bulawayo, Machwingo, Mataveleland North, Mataveleland South, Midlands, Manicaland, Mashonaland East, Mashonaland Central, and Mashonaland West. During the pre-election phase, the mission consulted key stakeholders, such as the Zimbabwe Electoral Commission, ZEC, key government agencies, leaders of political parties, representatives of faith-based organizations, media, civil society organizations, and the heads of international election observation missions. The preliminary statement covers the mission's observations of the pre-election period and voting day activities. The mission's final report will cover in more detail the observations of the pre-election and the post-election phases, and is aimed at supporting and strengthening the democratic electoral processes in the Republic of Zimbabwe as a SADC member state. Now, here is the summary of our findings. Your Excellencies, ladies and gentlemen, I now wish to share the summary of the mission's key findings. A, political and security environment. After consulting widely with stakeholders, the consensus was that the country was generally calm and peaceful. Constitutional and legal framework for the elections. The mission noted that the 23rd of August 2023 harmonized elections in Zimbabwe were regulated by the Constitution of the Republic of Zimbabwe and the Electoral Act of 2013. According to Section 158, Section 1, Subsection A of the Constitution of Zimbabwe of 2013, general elections should take place more than 30 days before the expiry of the 5-year period specified in Section 143 of the Constitution. The mission noted that this section applies to the duration and dissolution of Parliament and stipulates that Parliament is elected for a 5-year period which commences from the date the President-elect is sworn in and assumes office. The mission further noted that Section 144 of the Constitution requires the President, by proclamation call, to set a date for a general election after consultation with the Zimbabwe Electoral Commission. Pursuant to this provision, His Excellency Emerson Dambuzo Mnangagwa, on 31st May 2023, issued a proclamation fixing the 23rd of August 2023 as the date for the presidential, parliamentary, and local government elections referred to as the harmonized elections. The mission was informed that a further proclamation was issued rendering 24th August 2023 as a polling day because of the delays experienced at certain polling stations. Furthermore, President Mnangagwa also proclaimed 2nd October 2023 for the runoff election to the office of president if such a poll becomes necessary. The mission noted that this proclamation was in line with the paragraph 4.1-3 SADC principles and guidelines governing the democratic elections, which requires that the date or period of elections is prescribed by law. C. Election management. The mission noted that the elections in Zimbabwe are managed by the ZEC, which is one of the 5 Chapter 12 of the Constitution Commissions, that is, independent commissions whose purpose is to support democracy in Zimbabwe. In terms of Section 235 of the Constitution, the commissions must act in accordance with the Constitution, and they must exercise their functions without fear, favor, or prejudice. D. Delimitation of constituencies. The mission was informed that the delimitation exercise that was conducted in 2022 by the ZEC was marred with controversy. In one way or another, concerned stakeholders claimed that the report that ZEC submitted failed to observe the constitutional requirements for such an exercise, and that there were also divisions among 7 commissioners of the ZEC regarding the veracity of this report. The main allegations made against the report was that it constituted gerrymandering and that it failed to observe the correct methodology for calculating the 20% variance constitutional rule with respect to minimum and maximum sizes of the 210 electoral constituencies. The courts dismissed legal challenges that were brought against the delimitation report of 2022. The mission, however, noted that there still remain questions regarding the delimitation exercise for the following reasons. Number 1, in its delimitation report of 2022, the ZEC rightly states that the Constitution recognizes the impracticality of having equal number of voters in each constituency by allowing the Commission to depart from this requirement with a stipulated margin. In this case, the Constitution in Section 161, subsection 6, stipulates that no constituency may have more than 20% more or fewer registered voters than other constituencies. The Constitution in Section 161, subsection 6, A to F, also lists factors that need to be considered when delimiting, since they are important during the exercise. However, the ZEC goes on to also state that, based on the provision of Section 161, subsection 6, the Zimbabwe Electoral Commission then calculated the 20% deviation from the national average voter registration expected in each constituency, which was 27,640. This yielded a deviation of 5,528 voters. Since the average number of registered voters was regarded as a stable benchmark against which delimitation of constituencies was considered and conducted, the deviation figure was added to the national average to determine the maximum number of registered voters that a constituency delimitated would contain. For example, now at 33,168. 2, the mission noted that the use of the average number of voters per constituency is inconsistent with the provision of Section 161, subsection 6, of the new constitution that was adopted in 2013. The word average appears in section 61A, subsection 6 of the old constitution of Zimbabwe, under which it was permissible to calculate the minimum and maximum permissible number of voters per constituency by using the national average as the baseline. The word average does not exist in section 161, subsection 6 of the new constitution, which deals with the same subject matter. The difference between section 61A, subsection 6, and section 161, subsection 6 of the old and the new constitutions, respectively, is far from being merely technical. Number 3, in the new constitution, and in the context of section 161, subsection 6, the maximum deviation is 20% of the voters registered in the constituencies. The new constitution uses actual constituency by constituency registered voter population, not the national average number of constituency voter population. To calculate the permissible deviation from the requirement that constituencies must have an equal number of voters. Mathematically, the two methods produce very different results and affect the equality of the vote concerning the elections to Parliament. On the other hand, since the country votes as a single constituency in the presidential election, the difference in the methods has no particular impact on the equality of the vote in that election. It was, therefore, not unexpected that ZEC would receive substantial criticism on this aspect of its latest delimitation report. Let me deal with the voters' roll. Some stakeholders decried the delay in releasing the voters' roll in a searchable and analyzable format as prescribed by the Electoral Act. Some stakeholders expressed displeasure that the delay in releasing the voters' roll resulted in missed opportunities for them to audit the voters' roll and therefore give the public confidence about the veracity of the voters' roll. According to the ZEC, there was, however, an opportunity that was provided for interested parties to inspect the voter roll as provided by the Electoral Act. In this regard, the mission took note of section 62 of the Constitution. This section provides that every Zimbabwean citizen has the right to access any information held by the state or by any institution or agency of government at every level insofar as the information is required in public interest. The mission also noted that in terms of section 21, the Electoral Act, the Commission shall within a reasonable period of time provide any person who requests it, and it also pays prescribed fee with a copy of any voter's roll, including a consolidated roll referred to in section 20, subsection 4A, either in printed or in electronic form as the person may request. Access to the voter's roll is also premised on the constitutional requirement that the ZEC must deliver fair elections. In the exercise of this function, the Constitution requires the ZEC to exercise this function. The Constitution requires the ZEC to ensure that those elections are conducted efficiently, freely, fair, transparently, and in accordance with the law. Following consultations with the ZEC, the mission was informed of the conflict created by the introduction of the Cyber and Data Protection Act, which enjoins all institutions and agencies to protect the privacy of information entrusted to them vis-à-vis the provisions of Section 21 of the Electoral Act, where the voters' roll, although containing the personal information of voters, i.e. names, date of birth, ID numbers, address, sex, is a public document open to inspection by the public. Such conflict has resulted in there being litigation around the voters' roll as aforementioned, where in one case an applicant does not want his information public, and yet in another, the applicant seeks an order directing that the voters' roll be unveiled. The mission acknowledged the concerns the ZEC raised above regarding difficulties related to releasing electronic versions of the voters' roll. However, the mission also noted that the law gives the Commission discretion to impose reasonable conditions to prevent the voters' roll from being used for commercial or other purposes unconnected with an election. In particular, the mission noted that Section 21 of the Electoral Act provides the following: where a voter's roll is provided in electronic form in terms of subsection 3, 4, or 6, its format must be such as follows: its contents to be searched and analyzed, provided that the roll may be formatted so as to prevent its being altered or otherwise tampered with. The Commission may impose reasonable conditions on the provisions of the roll to prevent it from being used for commercial or other purposes unconnected to an election. Apart from the above safeguard measure against the abuse of the voters' roll, there is also room to note that a constitutional body, the ZEC, is obliged to give effect to the Constitution as to the supreme law. In this regard, the requirement for transparent and fair elections, instead of relying on legislation, the Cyber and Data Protection Act, that negates the specific requirements. In addition to the fees levied to access to the printed voters' roll, the mission notes that the above scenario is restrictive regarding access to the voters' roll by interested persons, including political parties. Freedom of assembly, F. The mission noted the controversy emanating from the Maintenance of Peace and Order Act, MOPA, which sets out a process for notifying the Zimbabwe Republic Police of the intention to hold a campaign activity. In this respect, there were stakeholder concerns about the right to freedom of assembly for election campaign purposes, whereupon the CCC reported that their rallies were being subjected to unreasonable cancellation by the Zimbabwe Republic Police. We also noted reports that there was inconsistent application of the notice period for election campaign gatherings, with certain political parties stating that the ZRP required a 7-day notice instead of a 3-day notice that is applicable during election periods, in accordance with Section 7(1)(b) subsection 2 of the Maintenance of Peace and Order Act. G. Freedom of expression. The mission received concerns from several stakeholders that the recent amendment of the Criminal Law, Codification and Reform Act, Chapter number 9, number 23 of 2004, which amendment is commonly referred to as the Patriot Act, has resulted in a severe restriction of the freedom of expression, which is guaranteed by Section 61, subsection 1 of the Constitution. The Patriot Act creates the offense of willfully injuring the sovereignty and national interest of Zimbabwe. Stakeholders were particularly concerned that this offense is vague, too general, and it criminalizes any communication between two or more persons, whether happening in person or virtually or by combination of both, which invokes or is facilitated or convened by a foreign government or any of its agents, proxies, or entities. Of note was also the concern that even the consultations between these stakeholders and international observation missions like ourselves could fall afoul of this law. The mission noted that the Patriot Act is incompatible with the spirit of Section 61, subsection 1 of the Constitution and paragraph 1 and 2 of the SADC principles and guidelines governing democratic elections, which requires member states to uphold, amongst others, the freedom of expression. H, nomination of candidates and nomination fees. The mission noted the unprecedented amount of litigation surrounding the elections, amongst others concerning the nomination process of candidates. In this respect, we further noted the protest and litigation of a Mr. Xavier Kasukuwere, who believes that he was unfairly disqualified as a presidential candidate. However, the courts dismissed this particular complaint. The mission further noted stakeholder concerns that nomination fees for a person to stand for election have become too high and therefore restrictive to political participation. In June, the government, through the statutory instrument 144 of 2022, increased the presidential nomination from the fee of $1,000 to $20,000. Nomination fees for a constituency election increased from $50 to $1,000. These amounts were also cited as unduly restrictive to less well-off members of the community, such as women who lack the means. In this context, we also take note of the significance of paragraphs 4, 1, and 7 of the SADC Principles and Guidelines, which requires member states to guarantee an environment of open contest with no undue exclusion and restrictions on anyone eligible and qualified to stand as a candidate in any election. I, participation of women as candidates. The stakeholders that also included political parties acknowledge the significance of Section 80 of the Constitution and the SADC Protocol on Gender and Development, which require that women be given equal opportunities as men in political, social, and economic activities. Despite the innovations that Zimbabwe has made, such as the provision of the 30% female quota in respect of councillors for local authorities, the mission noted that a lot more needs to be done to achieve gender parity in contested elected political positions. In this regard, our mission was advised that in 2023, fewer women actually succeeded in their party's primary elections, and effectively less women stood for the National Assembly, while only one woman stood for the presidency. Amongst others, this could also be attributed to the high nomination fees. J, independence of the judiciary. In view of their significance in the event of legal challenges in the context of the electoral process, some stakeholders expressed the view that the government compromises the judiciary. A key justification for this perception was information received from these stakeholders that the judiciary recently received large financial and material incentives, which the stakeholders viewed as an attempt by the government to buy the loyalty and allegiance of the judiciary. K,